Today, we're thrilled to have Sharon Apple, Associate General Counsel at Nestlé Nutrition North America, Eric Booz of Shook, Hardy & Bacon, L.L.P., Linda Clark, Deputy Counsel for Data Security and Information Compliance at Reed Elsevier, Susan Divers, Senior Vice President and Assistant General Counsel for Global Compliance for AECOM, Laurie Novion of Shook, Hardy & Bacon, LLP, and Cynthia Stamer of Cynthia Marcotte Stamer, PC. And now I'd like to turn the program over to today's moderator, Tom Hagee. Tom?
Thanks, Kathleen. This is Tom Hagee with HB Litigation Conferences on behalf of LexisNexis and all of the panel. Thank you all for joining. We have a very large nationwide audience today with a lot of hot topics. So we'll move right into the first one, and this will be on cyber threats, and this will be with Linda Clark from Reed Elsevier, LexisNexis. Linda?
Thanks, Tom. I'll jump right in so we can keep to the 9 and 90 plan, although the topic could be 2 to 3 weeks long. We see data breaches in the news on a daily basis, and the consequences can be severe. So what can counsel, inside counsel or outside counsel, do as a starting point? Today we're going to do a high-level overview. There are 2 key components. One, preparing by designing a comprehensive information security program, and 2, responding when an information security incident, and note I didn't say breach, I said incident, because what constitutes a breach is an amorphous thing. So the second thing is responding when a security incident occurs. You want to have an information security program in place that at a minimum meets the legal obligations that may arise based on how you as an entity interact with certain information. And you certainly don't want to be drafting an incident response plan while you are actually responding to an incident. Thinking through this when you have the benefit of time is key because you want to be prepared. So let's dive in. There are various laws that apply to how you have to protect information and what kind of information needs protecting. Today we're focusing on U.S. law, but there are also global regimes as well. In the U.S., there are state-specific laws and also sector-specific laws. For example, Massachusetts has promulgated specific standards for the protection of personal information for their residents. Likewise, HIPAA and HITECH set out addressable and required controls for protected health information, electronic health records, etc. And that's just what's required to protect the information. Almost all states also have their own data breach notification laws regarding notification to consumers, regulators, credit reporting agencies, etc. But there is a variation among those laws. Certain states define a notifiable breach as one in which the incident has placed consumers at risk of harm. Some states don't require that threshold be crossed. So it's important to understand the spectrum here and what is expected and required of you, and to build that deep knowledge into your information security program. Again, in the international context, there is a wide variety of what you need to do to protect information, when you're pulled into the regulatory scheme, and what specifically the expectation is of you if something occurs. So again, it's a good idea to build in those legal requirements either domestically or internationally. We're going to go over now some suggestions for how you can design your program, who should be on your team, and how you build support for that program. The first step is to figure out as much as you can what information you have. And I mean what information you receive, what information you transmit, what information you are entrusted with. Look at your core businesses and what information you deal with there, whether it's trade secret, confidential business information, personal information about employees or anyone else, and who your audience will be when you talk about security. When security is your selling point, your value proposition, the way you differentiate yourself from competitors and show regulators and others that you're doing what you need to do. For example, you may choose one framework if you routinely deal with the federal government and another if you routinely deal with financial services. Once you have selected your framework, and there's many, there's NIST, there's Cobalt, there's ISO, there's a lot of choices here. You want to develop administrative, technical, and physical safeguards to protect the information, and then develop corresponding policies and procedures and controls. Once you've done that, you need to make sure people understand in a very detailed way what that means to them. What are they required to do? It's important to include a process for appropriate governance of this, including how you review requests for exceptions, how your business functions, and also to monitor for ongoing compliance. Your program should address internal and external risks and also your third-party vendors. And of course, you want to include a detailed strategy for responding when something may have or actually has gone wrong. Document that plan, not just incident response, but going back to those administrative, technical, and physical safeguards that you will employ. Doing that will help you identify any gaps, clarify individuals' roles, and also keep everyone tasked in following through and responding if something does happen. Don't let your program go stale. Update it on a periodic basis, measure whether it's working, develop a culture of security, and embrace feedback that you get within your organization and from outside experts. Be prepared to adjust your plan. Make reviewing it a routine practice. That all sounded very simple, but an information security program can't be developed in isolation, and when you start drafting the nuts and bolts, you'll see it's not simple at all. What may sound like a good idea may not account for the risks throughout your organization and may not actually be workable. So here we have an example of a governance structure, just to throw it out there. The key is to have subject matter expertise represented by the working groups here that feed into senior level decision making, and you may have many tiers of working groups. You want to make sure you have someone accountable for making decisions, but also that you make sure that the right people have been and continue to be engaged in those decisions, and that if your program is under scrutiny, it's defensible, meaning it complies with the expectations, whether those are driven by legal obligation, customer expectation, or the regulators to whom you report. Again, this is not something that you can develop in a bubble. There are many competencies that filter in. In a large organization, that may mean many people are engaged. In a smaller one, it may be one person considering many perspectives. But let the development of your program be an iterative process. Some things to think about. Certain subject matter experts, legal, security, meaning infrastructure, physical, application security, and human resources are good to bring to the table. And you also want to have a diversity of skill sets and levels. Include external advisors where it makes sense. You do not want to be getting their information ready and vetting a forensic expert or outside counsel when you're in the middle of a situation. You want to have contact numbers at a minimum ready to go. You want to make sure that you are set up to make the hard decisions up front and in responding, and that involves having the right decision makers knowing their level of expected engagement. Building support is obviously becoming easier with the headlines that we're all seeing now. It's an expectation of your customers, consumers, and regulators, and it is a common term for your contractual obligations, whether you are being asked to sign or you're pushing those out to a third party. Again, you want to make sure you build this towards success. The keys to success, again, are going to be executive and senior management support for your program, which you get by having people engaged at the beginning. Assess what your risks are specifically and how an incident could impact your business. Quantify those risks, but also be prepared to tell a story. Make it a narrative as well. Make sure you have the right policies and procedures in place, that people understand what they need to do, build in mechanisms for them to do it, and for you to confirm that they are following through. Take this seriously. Make sure security becomes part of your culture. And with that, I will say thank you, and I remain available for questions after. But I want to cut it off now, so I stay with my 9-minute time slot. Thank you.
Well well done as usual. Thank you, Linda. So now we're moving on in the same general category. We're going to move on now to Eric Booz with Shook, Hardy & Bacon on privacy class actions. Eric?
Thank you very much, Tom. And thank you, Linda. I think that those prescriptive measures that you've outlined there can go a long way to helping general counsel, internal counsel, prevent exactly what I'm talking about right now, which is, unfortunately, privacy class actions. And we're seeing, as the years go by, and privacy class actions becoming more and more a part of the legal landscape. Just some figures to put this all in perspective. Through last week, I believe Friday of last week, we've had over 500 reported data breaches this year. And that compares with 620 breaches in all of 2013. And so as we can see, that's a 30% increase, which was a 30% increase, I'm sorry, from 2012. And so year over year, we're seeing double-digit increases in data breaches. And these are, unfortunately, turning more often than not into some sort of litigation. We had nearly 18 million individual records accessed so far year to date. And the average cost of a breach this year has been about $3.5 million, and that's from discovery, forensic reporting, through analysis, and any potential litigation. And that breaks down to approximately $145 per lost record in the breach. Surprisingly, I think to many people, internal threats, such as contractors, vendors, employees, only make up less than 10% of the data breach root causes. And what we're seeing more and more is external factors such as hackers and outside parties gaining access to systems and then constituting a breach of that data system. And as Linda so eloquently just explained, how important it is to have a formal strategy to protect your information assets, surveys have found that only 45% of companies to this point have a formal strategy to protect their information assets. With a few exceptions, once these data breach incidents turn into class action litigation or even an individual litigation, courts are generally still dismissing these class actions on the basis of plaintiffs not being able to allege an injury in fact. And I'm going to be the bearer of bad news here. Unfortunately, I'm talking about the data breach statistics, and now I'm going to bring us all back to first year of constitutional law, and we're going to talk a little bit about standing, just to review everyone. Article 3 standing requires a plaintiff to plead injury in fact, and that injury has to be both concrete and particularized and actual or imminent. And this injury has to be fairly traceable to the actions of the defendant. And what we're seeing more often than not when these cases are dismissed is the plaintiff is not able to sufficiently allege Article 3 standing, and so these cases are dismissed. And the Supreme Court had its turn at this very issue, Article 3 standing, in February of last year in a case called Clapper versus Amnesty International, and it's become sort of a cornerstone of data breach litigation and the motions to dismiss that accompany them. In Clapper, it was attorneys and media types that worked with foreign clients alleged that they were likely to be more targeted for surveillance under FISA than the ordinary individual, and they sued the government. And ultimately, the court found that the plaintiffs could not allege an injury in fact because the chain of events that needed to occur before those plaintiffs would be harmed was not certainly impending. And that's the standard that we're seeing in these data breach cases that is applied, is this certainly impending standard. Since Clapper, the vast majority of dismissed data breach cases have been dismissed on standing grounds. And a prime example of this is the recently decided case, In Re Science Applications out of the District of D.C. Science Applications International was a tech subcontractor for the federal government, and they handled the processing of data for various entities within the federal government. And specifically to this particular litigation, they were handling the insurance and medical information received by TRICARE, who provided insurance coverage and various other medical services to service members and their families. The In Re Science Applications litigation was an MDL that arose from the theft of data tapes from a parked car. A Science Applications IT worker had stopped in a not particularly fantastic area of the District of Columbia on his way from one facility to another, and he spent a fair amount of time there. and his car was broken into, and the thieves stole his GPS system stereo. But importantly, they stole the backup data tapes that contained personally identifiable information and personal health information for about 4.7 million members of the U.S. military. This information included Social Security numbers, names, addresses, and all sorts of treatment information. It was really the criminal identity theft gold mine in one location. And plaintiffs, they asserted 18 counts against science applications, including the increased risk of identity theft, the expenses incurred, mitigating this identity theft risk, the loss of the value of their information, failure to meet industry standards. This is sort of the litany of claims that we see in these data breach cases. And the court dismissed 31 of the 33 plaintiffs from the case, of course, on standing grounds. Relying on Clapper, they found that until the plaintiffs could actually allege that their records were viewed, or alternatively, that were certainly able to be viewed or to be viewed, any harm to their privacy was speculative. Now, interestingly, 2 plaintiffs did survive this dismissal. One was a former Navy employee who received letters relating to personal loans that he never applied for, and the other was a Georgia woman who claimed to receive telephone calls offering medical services for conditions that she had listed in her medical record, but she had never told anyone about. And so the court found that these were enough to cross the threshold and find that standing did exist. And so we have another case, very recent, actually came out last Thursday, In Re Adobe Systems Privacy Litigation. And we're going to talk about that because it's a very interesting case. But I'd like to talk about a few other cases first before we come back. We'll circle back to Adobe Systems. Resnick versus AvMed is sort of the flagship case where plaintiffs have begun to survive motions to dismiss. And these are still the vast minority of cases. Not many of these data breach cases are passing the motion to dismiss stage, but we are seeing a few of them, and they're starting to coalesce around certain theories of damages and standing. And so it'll be interesting to see what the future holds. And Resnick versus AvMed was the flag bearer for this, which was another class action where unencrypted laptops were stolen from AvMed's corporate offices. And the district court dismissed the case on standing grounds. This was pre-Clapper, but still the district court found no standing. But the 11th Circuit reversed. They found that it would not have been enough for plaintiffs to allege that they had financial data compromised following the theft. But because the plaintiffs alleged that there was an explicit connection between the stolen materials, the laptops, and the subsequent opening of bank accounts and credit card accounts, that was enough to constitute an injury in fact and to confer standing on the plaintiffs. Of course, once the 11th Circuit reversed and sent back to the district court, the case later settled for about $3 million, and each class member received about $10,000 of that. And AvMed was also forced to agree to certain security safeguards and security awareness and training programs. Another case where the plaintiffs have survived the bar is In Re LinkedIn user litigation, which is the case out of the Northern District of California, which is also where Adobe, which we're going to talk about in a second, was recently decided. In LinkedIn, plaintiff sued LinkedIn alleging that she paid for the premium LinkedIn subscription, but she would not have paid for that premium membership if she knew that LinkedIn had lax security practices. And of course, hackers infiltrated LinkedIn's computer system in 2012. I think all of us heard about that. And they stole approximately 6.5 million usernames and passwords. And a lot of the state data breach notification laws that Linda had discussed are all starting to incorporate usernames and passwords as protected information because, unfortunately, users tend to use the same usernames and passwords throughout systems. So once you get access to one, you may have access to many more systems.
Okay, Eric, so we're going to have to go to the highlights at this point.
Yep. No, I think we're good here. And, of course, in LinkedIn, the court found Article 3 standing because she purchased her premium subscription in reliance on LinkedIn's misrepresentations about their industry standard security. Similarly, in another case, Tabata versus Charleston Area Medical Center, the court found that where the plaintiffs have a concrete, particularized, and legal interest in having their medical information kept confidential, and I think that would probably be everyone, standing does exist. It is an injury in fact. And so just to go back to Adobe for a quick second, Adobe is a recent class action involving customers who had purchased Adobe licensed products. And I'm sure all of us have heard about the Adobe breach, where approximately 48 million Adobe customers were potentially affected. Excuse me. In Adobe, the court did something that we haven't seen before, and that we're going to have to pay attention in the future, where she found, the Judge Coe, who is a very well-respected judge, found that because plaintiffs could allege that, that the accounts were hacked and the hackers would not have accessed their account unless they wanted to misuse their information, this was sufficient to confer standing under Clapper. And so for the first time, we're seeing a district court utilize Clapper and sort of distinguish Clapper in a way that allows data breach plaintiffs to pass the standing hurdle. And so again, it's just one district court in California, but these cases tend to build off each other, and so it's something we're going to have to watch as we move into 2014, 2015. Tom, I think that'll about wrap the data breach portion up.
Okay. Go ahead and jump into intellectual property now.
And so to stay within the realm of electronic data and other sorts of intellectual property, 2014, much like 2013 and 2012 to a certain extent, is all about patents, and more patents, really. We've seen some movement in the Supreme Court considering trademark cases, but a lot of them have been procedural and not really to the substance of the Lanham Act or any particular trademark law, but patents continue to overshadow the IP field. In 2013, we've had over 300,000 patents granted, and patent cases, the litigation resulting from patents, grew by another 25%. Importantly, 67% of these patent cases in 2013 were filed by non-practicing entities. And this is sort of the term of art that's been instilled on what's more colloquially referred to as a patent troll. And so we're seeing 67% of these lawsuits are being filed by patent trolls, these NPEs. And the median damages in these cases are about $4.3 million. And we're seeing similar models of damages alleged in these cases, and the payouts are generally falling along the lines of reasonable royalties and lost profits. These are the damage theories that we're seeing in patent cases. Interestingly, 4 particular district courts are dominating the patent litigation filings. The Eastern District of Virginia, the District of Delaware, the Eastern District of Texas, and the Western District of Wisconsin. And generally, these 4 districts are considered particularly friendly to patent holders. And whether those patent holders are companies that are actually utilizing their patents and selling products based on their patents, or they're these non-practicing entities that purchase patent portfolios and sit on them to sue, these districts are particularly friendly to this type of litigation. Another point of note, I'm here in Miami, Florida, and we had a patent pilot project running in our district courts down here where certain patent litigation would get shuffled to particular judges so that they could develop expertise, and these cases can be fairly complex, and so it would theoretically reduce costs for the litigants if they had an experienced judge who knew the ins and outs of patent litigation. And we all just received note today that South Florida was ending, the Southern District of Florida is ending its patent pilot project, and one of the main bases of this termination was the fact that South Florida was becoming a hub of patent litigation for these non-practicing entities, just too many filings, and it was doing things to the dockets down here that I guess the Southern District was not a fan of. And so we will be ending our patent pilot project down here. And I would anticipate that as patent filings continue to increase and these non-practicing entities are behind them, we'll have to see what the courts are going to do. So software and business method patents, along with the rest of patents, have seen a significant increase in recent years. James Besson, who's an academic that specializes in this particular area, has characterized it as the patent troll crisis is really a software patent crisis. In a GAO study, we found that 90% of patent litigation, the patent litigation increase, is related to these software patents. And that's interesting because patents require that there be an invention, and software and business method patents are often fairly abstract, very vague, and I think that we see this a lot in things like cell phone use here, with the slide to unlock feature everyone's familiar with, or the activate function, the swipe open function. These are claims that probably everyone is familiar with, and they're all describing the same things, but we have 3 different patents that have essentially been issued for the same exact functionality, the same invention, and you can see how this would lead to a significant amount of litigation. And finally, the Supreme Court decided to review whether or not software patents, these things that are fueling this massive increase in patent litigation, whether software is patent eligible. And just to review patent basics really quickly, you can't patent abstract ideas. You have to have an invention tied to that idea. Business method patents fall along the software patent line. They're sort of the manifestation of an abstract ideas, but they're relatively new and they're relatively shaky. The Supreme Court has reviewed business method patents, but it did not give a ringing endorsement to them, and so we're still on sort of a shaky ground when it comes to business method patents. Regardless, the case that the Supreme Court decided to take was called Alice Corp Party Limited versus CLS Bank International. And Alice Corp owned patents on electronic methods for settling financial trades. They didn't patent a specific implementation of the system. They just patented the idea of settling trades between 3 parties. They never produced any invention. They never incorporated into a computer system or any sort of algorithm. Nor did they ever use their patents in business. They were essentially a patent troll, a non-practicing entity. Whereas CLS developed an actual product based on a similar but not identical process. When this case got up to the Federal Circuit, everyone agreed that the Alice Corp patent should be invalidated, and it was because it's merely an abstract idea. You can't add on a computer to a business method patent to make it patent eligible. You actually need to incorporate it into some sort of an invention, some sort of an idea that you can put into practice. And many found that Alice's idea was just too obvious, was just too abstract to be patented. And the Supreme Court spoke and invalidated Alice Corp's patents, much like everyone thought they would, and said this is the most concrete sort of ruling that they gave in that case. It's merely requiring generic computer implementation fails to transform an abstract idea into a patent-eligible invention. And essentially what they're saying is that abstract ideas plus the phrase on a computer is not going to be enough. Unfortunately, the Supreme Court has not given much more guidance than that. And so courts are still going to be left from this point until the Supreme Court decides to take this up again, trying to figure out what transforms, what pushes an abstract idea from the realm of non-patentable subject matter into a patentable invention. Interestingly, the Alice Corp opinion never used the word software. I think the Supreme Court took great pains to make sure that they weren't writing an opinion just to apply to software patents. The opinion also seems to let business method patents survive, but it's not quite clear as to, again, how business methods have to be written, business method patents have to be written, what the claims have to look like in order to be transformed from this abstract idea into patentable subject matter.
Let's just take one more minute, okay, Eric?
Yep, we have one more slide, so we're almost there.
Excellent.
So, again, I think this just shifts the debate back to whether an invention is merely an abstract idea. And, again, little guidance from the Supreme Court, and so hopefully the Federal Circuit will come down with some guidance in the next few months so that parties know what it is that they need to do to assert valid patents. And so just one more piece of intellectual property news that is probably fairly relevant to most of us here on this call today, and that's that Congress is finally considering a Federal Trade Secrets Protection Act, and I think that this will be quite useful to many who have to practice in multiple jurisdictions, who have business units in multiple jurisdictions. Essentially, this would create federal trade secret protection that would adopt all of the protections of the Uniform Trade Secret Act. Many states have already adopted the Uniform Trade Secrets Act, but they've adopted it in their own way, and we have differences between jurisdictions. Importantly, parties would now be able to seek injunctive relief, preliminary injunctive relief, that would essentially freeze the assets, the trade secret assets of the corporation, the entity that is infringing on those trade secrets. It'll also lengthen the statute of limitations under the Uniform Trade Secrets Act to 5 years, so companies have a bit longer of a period of time to bring actions when they discover that their trade secrets have been misappropriated. We have support from both parties for this act. We have statutes in both the Senate and the House, and so now it's just a waiting game to see is whether or not we can get this pushed through before the end of the year.
Excellent. Thanks, Eric. Thanks for taking 2 sections as well. I appreciate that. Okay, now we're going to move on to anti-corruption regulations with Susan Divers of AECOM. Susan?
Yes. Hi. Thanks. Well, this is an area that really is made by case decisions, or settlement decisions, I should say, rather than legal cases. I've heard that referred to as gray law, and I would agree with that. But what that means is to understand what's going on, you really have to look at the cases and read them in some detail. So in the 9 minutes I've got, I'm going to try to go through 9 cases and just point out really kind of the key features. So starting with that, the Alcoa case was the big case in the last 12 months. And as you can see, it's close to a $400 million settlement. And there are 2 things about it. I mean, it's kind of an interesting read because it involves the Bahraini royal family, a shadowy middleman, shell entities, and about $200 million in bribes. But the main 2 points I would make about this case is, one, that it did involve a shadowy middleman who added no value in terms of what he actually brought to the transactions. And that's something that it's really important for companies to look at and test for when they do internal audits. So it's a good cautionary tale, if you will, in that regard. And the second point I would make about this case is that Alcoa argued that its subsidiaries were separate. And indeed, you know, that is a legitimate legal argument. But the SEC looked at the fact that they appointed a majority of representatives on one subsidiary's strategic council, that they set business and financial goals, and that the subsidiary's employees who oversaw the business reported to an Alcoa manager, and that this was also a significant customer, the subsidiary, and they met with Alcoa officials fairly regularly. So what that tells you is you can't just rely on a legal distinction that that's a wholly owned subsidiary or a wholly independent subsidiary. You have to look at what actually happens in practice in order to really assess risk. Turning to the next case, this is Cobalt Energy, and it's an announcement last month that they're under formal investigation for FCPA-related violations in Angola. And this was an interesting one. When I sent it out to our business team, they said, wow, it really shows that you have to do good due diligence. And they were right. Basically, one of the partners for Cobalt, called Nazaki Oil and Gas, turned out to be owned by 2 high-ranking Angolan generals and a minister. And Cobalt undertook an internal investigation when the SEC requested that in 2011, but apparently that wasn't enough, and now they're under formal FCPA investigation. And, you know, it's possible that that none of this will come to charges in any regard, but it's a very good illustration of, again, two things. One is that you have to do adequate due diligence on your partners, agents, and business associates to avoid liability, because it's almost a strict liability standard in practice in some regards. And secondly, a lot of times informal requests for investigations, according to our outside counsel, don't result in any formal investigation, and clearly that would be the goal, but this may be an indication that you really have to make sure that those informal investigations are completely thorough and completely credible, and AKA expensive, in order to meet that standard. You know, I don't know that for a fact in this case, but that's my guess. Turning next, there was some interesting guidance that came out in May from the U.S. Court of Appeals for the 11th Circuit in a case that bears on the issue of what is a foreign government entity. And as probably everybody on the call knows, state-owned entities are subject to the FCPA dealings with state-owned entities, because state-owned entities are considered to be part of a foreign government for purposes of bribery. And again, in the past, there's been a fair amount of debate about, well, is it a state-owned entity or isn't it? And there are various lists and services that you can get to help make that determination. But the two-part test that the court looked at in this instance basically took a very fact-intensive perspective, looking at different factors, including what you would expect. You know, what does the foreign government call it? Do they have a majority? Can they appoint and remove the principals? What happens to the profits? Whether the government supports an entity that's otherwise performing at a loss, and the length of time that the above factors existed. And then they went further and they looked at public function, and they said, does the entity have a monopoly? Is it subsidized? Does it perform services for the public at large? And what do people think? Is it a public entity? So based on that, the court determined that Haiti Telco, the telephone company in Haiti in this instance, was in fact a public entity. So these are interesting criteria to take a look at when you're struggling with that in your company to determine the level of risk in dealing with different customers or entities. The next case is the Bilfinger case, and it's always worth noting that this is a German-based company that's traded on U.S. exchanges, and they now have to pay a $32 million penalty with respect to bribing government officials in Nigeria. And it also relates to an earlier prosecution of Wilbros. Basically, the two companies, Bilfinger and Wilbros, formed a joint venture to bid on a Nigeria project and inflated the price of the bid in order to cover the cost of paying bribes. And at one point, when there wasn't enough money to make their share of the bribe payments, Bilfinger loaned Wilbros $1 million with the express purpose of funding the bribes. So sometimes bribes aren't obvious, and that they can be funded by this type of overcharging or even substituting lower cost personnel for higher cost personnel in order to generate the margin in order to pay them. So what this tells us is that there's really no substitute for good internal audit, and for auditors who are really well trained and can carefully review and pressure test payments, especially in high-risk jurisdictions like Nigeria. There's also no substitute for honest business folks who would say no to something like that.
So Susan, you'll have to kind of hit the high points now of these. You have a lot of cases, but I appreciate it.
All right. Okay.
Do your best.
I'm going to gallop through. So ADM, this case really is a good illustration of paying to get an unfair advantage, in this case expedited tax refunds, and that is an FCPA violation. That's not a facilitating payment. Facilitating payments are very small payments made to get someone to do something they're supposed to do. The National Geographic Society case is interesting from the point of view that there were allegedly payments and gifts to a very prominent Egyptian archaeologist, allegedly the basis for Indiana Jones, and they're under investigation as a result. So be careful with gifts and entertainment always. GHD, this case involves a firm that has been barred by the World Bank in the wake of allegations that they made payments in order to get work in doing work in Indonesia. And this is an Australian firm. And again, it involves a marketing fee and inflated housing reimbursement requests. I put this in here because the World Bank is substantially upping its scrutiny of contractors. And there's quite a lot of evidence of that and talk about that in the anti-corruption community. Next, BHP. And again, I think this is an interesting case. BHP spent millions of dollars on a major Olympic sponsorship for the Beijing Olympics, and it seemed to be pretty substantial and excessive, with 170 VIPs being wined and dined. So, you know, items like Olympics, events like the World Cup really do need a lot of guidance and scrutiny from the compliance team to make sure that things don't go awry. The Diebold case, this is an example of where the company obviously had loose controls because they were using both cash and all expense paid trips in order to wine and dine clients and win contracts in China, Indonesia, and Russia. So the SEC charged them with falsifying their financial records because they were hiding these gifts and all. So again, internal controls is really the key. And I see one question, does the FCPA apply only to publicly traded companies? And the answer is yes, it does up to a point, but the internal controls aspect can go beyond that. Let's see. I think that's it in terms
of... Susan, it's back over to you. So we'll just borrow a minute from your next segment, if that's okay.
That's fine. Okay. Sorry, I may have seen a little too much there. But the next segment is OFAC and sanctions. And this is an area that I find really people don't pay enough attention to unless they're a financial institution. And we'll take a look at some of the cases and some of the sanctions that have been put out. And even if you're not a financial institution, which we clearly are not, you really do need to pay attention to this area because you can easily wind up with a violation. And this case in particular is very recent, and it says basically that one of the German banks is about to probably pay a fine close to $700 million because of sanctions violations. And it's because they apparently provided banking services to Iranian shipping lines. You really have to screen your customers. We use one of the outside screening tools, and we do it as widely as we can because even though we're not a financial institution, we want to know that our customers or our associates are not on the sanctions list. The next case, the Citibank case, shows that even a first-class financial institution can sometimes have a problem. And in this case, Citi's unit processed 4 export bill collection applications that involved the shipment of goods to Iran. And that is just something that is always going to attract regulatory scrutiny and fines. So in this instance, their screening software didn't identify references to the sanctions parties, and they processed the payments without manual intervention. So it just goes to show that being very careful about what you're doing in anything involving the sanctioned countries is absolutely essential. The next case is actually new sanctions that were posted just in August as part of the ongoing effort to rein in Russia's intervention in the Ukraine. This is something that, again, if you do business in those areas of the world, you really do need to stay on top of because the sanctions are changing in scope and name pretty regularly. And it's a customer that is not on the list one day can be on the customer the next, can be on the list the next. The next case is United Shipbuilding, and this is a blocking order because United Shipbuilding manufactures basically military and shipbuilding repair and maintenance products and provides those services. So the Treasury Department has sanctioned United Shipbuilding, and no one, no U.S. person can deal with them. So whenever you have activity in the military or the high-tech area or any kind of sensitive technology or controlled technology, then you really do have to exercise care to make sure that you're not dealing with, you're not violating sanctions. You probably also have to look at the export control laws very carefully as well. Bank of America, this is another first-class financial institution that had a fairly minor error in that they processed transactions for 6 designated narcotics traffickers, and they failed to file timely reports about 4 other narcotics traffickers. And in some cases, it turned out that the bank was aware that they had gaps in their screening system, but they didn't fix it, and this is what led to the fine. They could have faced a larger penalty, but the penalty was reduced because they said they would fix the system, and some of the transactions may have been eligible for a license. So it's an indication that even for fairly minor gaps or mishaps, there can be fairly significant penalties. The next case, BNP, is the big case in this area. BNP is a French bank, and it was fined close to $9 billion for U.S. sanctions violations. And there have been criminal charges against some of the executives because the company was basically doing business with sanctioned entities in Sudan, Iran, and Cuba, and they concealed the names in an effort to basically continue doing the business despite inquiries from their compliance team. So the size of the fine and the guilty plea from the CEO send a really strong message that you really have to make sure that you're not violating sanctions. And I think it's another indication that audit and assurance are really some of the best defenses to ensure that that's in fact the case. And that ties into the next slide, which has to do with the U.S. Treasury penalizing nearly 3 dozen companies and individuals in 8 countries back in February for evading Iranian sanctions. And 18 businesses and 14 individuals were identified in a whole host of countries. Some of them were helping Iran circumvent U.S. sanctions, and others were accused of involvement in illicit activities in Afghanistan and Syria. And one example from that case is Advanced Electrical and Industrial Technologies, a Spanish company, was penalized for helping Iran procure specialized nuclear equipment, and a Turkish citizen was penalized for helping an Iranian company try to reverse engineer an armed speedboat to be used by the Iranian Revolutionary Guards. So drilling it into your business team that anything involving Iran, anything involving Syria, anything involving Cuba, North Korea, obviously, can be a real problem, and is not only a red zone issue, it's probably a radioactive zone issue, and that they really need to check in with legal right away and not do anything. Otherwise, they run the risk of really getting tangled up in some very serious violations. The next slide really deals with the different Russian sanctions that have been put in place, and it's up there really as an illustration of how quickly this area can move. In March 17th, the White House put out the first executive order that blocked some assets and banned visas for some individuals that were involved in the Ukrainian sovereignty crisis. And the EU did that as well. And what I did is I copied some of the advice we've put out on that. It says check the MK denial database to make sure that you're not getting in trouble in that area. Then on March 21st, the White House expanded the sanctions and included several more Russian officials and a bank in response to the crisis. Then in April, they expanded the sanctions imposed in the March 17th order to include 7 more Russian government officials and 17 entities. So this space is changing very rapidly, and in order to make sure that you're not violating the new sanctions, you really do have to keep checking in to make sure if you're doing business in Russia or with Russian entities that they aren't on the prohibited list, because that will affect your ability to carry out the contract, and it could attract fines as well. Then just a peek into the future, as of yesterday, there were press reports indicating that both the EU and the U.S. plan to impose new sanctions targeting Russian sectors, probably oil but not gas, individuals and companies. So if your business team is actively involved in dealing with customers in that space, I would suggest a daily check-in to make sure that you're not falling afoul inadvertently of any kind of sanctions. Thanks. I think I got that.
You did great. Thank you. Thank you, Susan. I've got a lot to cover in a short time, as all of these are. So next we're going to move on to antitrust. And is this Laurie?
Thanks, Tom.
Laurie Novion from Shook Hardy. Go ahead.
So companies regularly hear in the news about antitrust regulations and related litigation and government investigations, but they often don't have a clear sense on what those regulations entail. So I thought as a starting point, it would be really helpful to just basically describe what the antitrust laws are and why companies and their employees should care about them and be aware of them. At a very basic level, the antitrust laws are designed to protect fair competition. And that's so that businesses and end consumers can pay a fair price for goods and services, and businesses can feel some comfort that they are being protected by unfair and anti-competitive actions of their competitors. This slide in front of you shows a variety of federal statutes that are kind of in play in the antitrust arena. And there's not much time right now to go into all of those in details, but clients and companies should also be aware that in addition to these federal statutes, there are a number of parallel and complementary state statutes. So companies could potentially find themselves confronted with liability under both federal and state law. Now, the reason why companies and their employees should care about these laws and should, dig in a little bit more deeper is because there are serious consequences for antitrust violations. Just focusing first on the criminal and the governmental side, the government through the Department of Justice has absolutely no problem going after businesses and their employees for antitrust crimes, and they've increasingly done so in recent years. In fact, it's really not uncommon to find corporate criminal antitrust fines that surpass over $300 million. And in addition to that, participating employees of a company can find themselves with fines of up to $1 million and can even be sentenced up to 10 years in jail. And then when you look at the civil side, you also have companies who have to pay defense costs for defending against oftentimes dozens and dozens of cases brought by different types of plaintiffs where if successful, the plaintiffs can get treble damages, attorney's fees, and there's also the potential of injunctive relief being imposed against a company. So when companies' in-house departments start looking at these statutes in a little bit more detail, they might just raise their arms in defeat and say, yeah, the only way I can completely avoid liability is to simply stop doing business. But that doesn't make any economic sense at all, and I certainly would not suggest that businesses shut their doors. I personally believe that businesses should be able to compete aggressively and profitably. And with that in mind, I wanted to very quickly share some basic best practices that I think companies can employ to help them avoid or at least minimize their antitrust exposure. The first, companies should avoid agreements with competitors that touch on prices to be charged to customers. These types of agreements, arrangements, or conspiracies are often referred to as price-fixing agreements, and they are violations of Section 1 of the Sherman Act, which says it's illegal for companies to enter into an agreement in restraint of trade. These are significant civil and criminal violations, and they are perceived to be a per se violation. And what that means is that a court is going to conclusively presume that the agreement is illegal and is not allowed to consider any business evidence of its underlying business motive or of the possibility that the conduct has pro-competitive benefits. And just so companies are sure, I just want to make sure they understand kind of the scope here. We're not talking about agreements or arrangements about specific prices or transactional prices for specific customers. It's much broader than that. These could be coordination on anything that touches on prices, such as discount rates, percentage increases, perhaps fuel charges, even in agreements to just keep prices level. So as a best practices, companies should do two things in this area. First of all, they should counsel their employees to avoid these types of agreements and arrangements in the first place. But secondly, companies should deal with what I would call good document management. You want to avoid the appearance that your company is coordinating with competition. And the reason for this is that circumstantial evidence can be used in support of a plaintiff's conspiracy allegations in these types of cases. So you don't want to have loose writing that somehow gives you circumstantial evidence of a conspiracy that never happened in the first place. Now, second point is to realize that in addition to price-fixing agreements among competitors, businesses should also be careful to avoid other types of illegal arrangements with competitors. Many of the arrangements that are listed on this particular slide are also per se antitrust violations. And there's certainly not time to go through all of them, but I wanted everyone to be aware of them, that they exist, and there are a number of factors involved. So as everyone could probably tell, competitor interactions is a potential danger zone in the antitrust arena. So my third tip is really for companies and their in-house departments to develop lists of what I'll call your do's and don'ts of competitor discussions and competitive intelligence efforts. And the purpose for these is to keep your company potentially out of trouble in the first place, and also the appearance of doing something inadvertently that your company never had intentions of doing so. On these materials, I've given some examples of what I think are good business practices for competitive discussions and competitive intelligence. For example, kind of on a very high level, to the extent possible, company employees really should minimize their communications with competitors. But I realize that's not always possible. Companies and their employees should be very careful in the trade association kind of scenario and involvement in those groups. And the reason for this is because there's an opportunity for competitors to informally get together. When you do speak with competitors, make sure you stay away from conversations that are going to talk about current or future pricing, customers, and the markets. I would advise companies to counsel their employees about a concept called noisy departure. So when you're involved in a trade group meeting or even a one-on-one meeting with someone and the conversation strays to an inappropriate antitrust topic dealing with prices or customers and upcoming market conditions, is for that employee to do something memorable, to stop the conversation, kind of comment that it's inappropriate, and either move on to a different topic or actually leave the room or lead the discussion. And then in connection with, in this area, in connection with competitive intelligence, obviously that's the lifeblood of many companies, but you should take care to have good documentation here so that when you're getting permissible competitive information from your customers or from the public, document where the information and even the source came from so that someone later in discovery and litigation can suggest that you in fact got that information from a competitor. Next, although compliance manuals often focus mostly on interactions with competitors, businesses should be aware that certain relationships with your suppliers, your dealers, and customers are also subject to potential antitrust scrutiny. So this slide kind of gives some highlights on a variety of circumstances that if the facts play out a certain way, they could raise antitrust regulatory issues. So they should kind of use the yellow flag out there for companies and their antitrust counsel. The two final points. So I hope, my fifth point is I hope businesses never have to get to this point, but in-house departments really should be aware of the Department of Justice's amnesty program because it might come out to help your company in a particular circumstance. So assume that your company is occasionally conducting audits or you get some caller inquiries to your compliance department. As a result of those, they might reveal a situation where you have a potential criminal antitrust violation. In those circumstances, your company should be considering the pros and cons of participating in the DOJ's amnesty program and actually self-reporting to the government. If you are, in fact, the first company to self-report and file within your industry, and there's no ongoing government investigation, and if you also qualify and meet all the qualifications for the program, your company is going to receive amnesty, which is going to protect you from criminal fines, and it's also going to limit your civil liability to single damages instead of treble damages. And finally, kind of as a wrap-up, if companies haven't done so already, I really recommend that you develop antitrust compliance manuals that can be part of a larger business practices manual, and that perhaps you even expand that into compliance programs. You want to regularly remind your employees about these guidelines. You don't want them just to read a policy once a year, quickly sign their name that they've read it. These are complex issues. They're somewhat hard to understand in the highly technical language in the guidelines. So face-to-face training where real-life examples and hypotheticals are given so the employees can see how these best practices play out in their everyday work environment are extremely helpful. You should also consider, instead of just focusing only on your high-level leadership positions or your employees with pricing authority, you should really think about expanding this to other levels. Employees who deal with your sales reps, for example, or buyers, or anyone else who's going to regularly have an opportunity to meet with competitors, talk about pricing, and go to trade group meetings. And then finally, in connection with your compliance program, just consider an overall good document management best practices approach. You want to manage your company's appearances so you don't inadvertently create documents that are going to be circumstantial evidence of a potential antitrust violation that never occurred. And finally, as you're working on these types of programs, you can obviously consult outside counsel, but those on the phone should be aware that there's a whole wealth of information that the Department of Justice and the FTC has posted to help companies in this compliance area on their websites. So I think that's it. There's all I can cover in my 9 minutes, but I hope this quick overview over a very broad topic area is helpful.
Laurie, thank you very much. We're going to move right over to Sharon Apple from Nestlé on wage and hour regulations.
Great. Thanks, everyone. So as we go through all the various hot topics, one area that continues to be a growing source of litigation for employment law is wage and hour. And just for the sake of having some interesting facts, in 2001 there were 397 cases that were filed, and now in 2013 there were 7,764, and this is just federal lawsuits under wage and hour law, FLSA cases that were filed. There was a great uptick in 2009 where the number of cases went up to 19%. In 2010 it went up 10.5%. Then it came down a bit where in 2011 it only grew by 1.9, and then from 2012 we see a growth again at 10%. So wage and hour is still here to stay and definitely worth employers' vigorous attention. Just to go through some of the very basics of the Fair Labor Standards Act, it does cover most private and public employees, and it requires that employers pay minimum wage to covered employees and overtime pay at 1.5 times their regular rate. The FLSA creates stringent record-keeping obligations for employers because ultimately if there is a lawsuit where plaintiffs are claiming that they were not paid for hours worked or not paid for overtime, there is a burden on the employer to demonstrate what in fact the hours that were worked and to have a process in which an employee could issue some correction to their hours. So ultimately, to the extent employers are on the defensive, we need to have that record keeping. The law is administered by the Wage and Hour Division within the Department of Labor, and something that companies should recognize is that there is the federal law, but that just the federal law just provides the floor, and states can certainly legislate and impose additional or greater requirements in the area of wage and hour. So when you're looking at a wage and hour issue, it's important to consider both federal and state law. Further in the basic requirements is the concept of whether employees are exempt and non-exempt. And the reason why that is important is because the non-exempt population are the ones who are eligible and required to receive overtime if they work over 40 hours in a work week. So it's important that the classification of who is an exempt or non-exempt is done accurately. In that regard, there's certain categories where there's exempt employees from overtime requirements, and there's various tests and categories. There's the executive, administrative, and professional. So there's an analysis that goes into who's considered exempt and non-exempt, and it's prudent upon companies to ensure that they are conducting ongoing annual reviews of their classification of their workforce, and certainly to the extent they're in a situation where they are initiating a new position or a new group, they should look very carefully at whether the role of the position is exempt or non-exempt, because you want to get it right from the get-go. The other aspect of the FLSA that sometimes becomes thorny is understanding what hours are considered working hours and therefore compensable time. And a hot area in the question of what's considered compensable time is in donning and doffing, and it comes from the idea of usually in the manufacturing environment where employees are required to put on a uniform and undergo certain preparation for their shift, and then certainly at the end of their shift they remove the uniform and safety gear. So there's a lot of lawsuits there known as donning and doffing in terms of understanding whether that time should be compensable or not. The interesting area of this is the difference between whether the lawsuit is brought under federal law or state law. And again, if you are working in a facility that involves a union workforce, and you don't compensate for that prep type of activity, the Fair Labor Standards Act recognizes an exception where the question of whether that prep time is compensable depends on the collective bargaining agreement or past practice. However, you also have to look at state law. And certain states are not very clear on this very issue. So if you have a manufacturing facility and you're unsure and you aren't compensating for donning and doffing, it's something you certainly should take a look at in terms of what does your state law or case law say as it relates to whether it's going to follow the Fair Labor Standards Act exception or not. The other complicated aspect of the FLSA is calculating the regular rate of pay. And that's important to do because that is the foundation to calculating what overtime is, because it's time and a half of your regular rate. And that can be somewhat complicated because if there's certain types of bonus programs, that may have to be accounted for in the regular rate. It also can get confusing because some employers have fluctuating work weeks. So the regular rate and the overtime is actually calculated on a week-by-week basis because the regular rate may not be a standard rate from week to week. The enforcement in the area of wage and hour continues to be strong, and to appreciate that the Secretary of Labor could bring a lawsuit for back wages as well as an equal amount of liquidated damages of what the back wages were. So it could be a pretty steep and high-risk cost if a company is doing something wrong, especially if it implicates a large group of employees. The Department of Labor is also getting involved in private actions. So it's something to be sensitive about as well. And the damages could also include in private rights of action the back pay, the liquidated damages, as well as attorney's fees and court costs. There's a 2-year statute of limitations, and if willful violation is found, the company could be liable for 3 years. Something to appreciate in terms of understanding whether employees would be considered exempt or non-exempt is that President Obama has directed the Department of Labor to modernize and streamline the overtime regulations, taking into account just the modern economy in terms of how the executive, professional, and administrative exemptions are defined. There is a White House fact sheet that focuses on particular the salary basis test, which is one of the tests used to evaluate whether a particular position justifies one of the exemptions or not. But this is something to look out for in the future because we based on the fact sheet, we suspect that the salary basis test is going to actually increase and broaden the eligibility or the criteria of who's going to be considered non-exempt. Another hot area for enforcement is appreciating whether there's proper classification for who's considered an employee and who is an independent contractor. And many companies rely on the use of independent contractors because if there's a certain service that is unique and and the company doesn't have the expertise, or certainly it is a project that is limited in duration, companies will often rely on independent contractors to perform those sorts of services. But this continues to be a hot area for the Department of Labor because sometimes the use of independent contractors by employers does get abused. And if they are a 1099 independent contractor, certainly the employer is not paying the typical employer portion tax to the government, and this is a rich area for the IRS to go after if they're finding that the classification is off. And things to look at are whether the independent contractor is exclusively providing services to that employer or not. Do they have multiple clients? What are their hours? Where do they perform their work? Is it at the employer's work site, or do they do it from home or their own office? Are they given a company computer, an email address? Do they work consecutively day after day? And how long is their engagement? Are they there year after year? And are there other employees essentially doing the same type of work as the independent contractor? And finally, how much control and direction is the independent contractor getting from the employer, or are they providing services where they're able to operate truly independently, but of course also making sure that they're providing the necessary services. So it's a totality of the circumstances in terms of the analysis. There's not one factor that necessarily will trigger a finding of misclassification, but this is another area that a company should pay attention to in reviewing their independent contractors and appreciating whether they're properly classified. The other area where the Department of Labor is really cracking down on, and frankly it's a hot litigation area, is unpaid interns. And in reading the news today, I learned that there was another lawsuit filed by unpaid interns in the broadcasting industry. The lawsuit was filed against CBS for the Letterman show. You often find in the entertainment industry as young professionals and students coming out of school are just trying to get their foot in the door. Certainly they are willing to take on any work and appreciate the opportunity and don't get paid for it. But this is becoming a hot area. You may all be familiar with a case coming out of the Southern District of New York, a 2013 decision, Glott versus Fox Searchlight Pictures. That case had to do with the film Black Swan, where employees filed a suit under the Fair Labor Standards Act where they claimed that they were improperly classified as unpaid interns. There is a 6-factor test that the Department of Labor has issued, and you could learn more about it in the April 2010 DOL fact sheet number 71. You could easily find it on the Department of Labor's website. But internships in the private sector, in the for-profit private sector, will most likely be viewed as an employee relationship and therefore should be paid. And the DOL designed a functional control test, and there's 6 criteria. One is the internship similar to training in educational environment. So you have to show a link to the internship, what they're doing on the job, to the educational environment.
Sorry to interrupt you, Sharon. You're gonna have to wrap it up. We've got to get to the Affordable Care Act. But sorry to interrupt. Go ahead and finish your thought.
Oh, no, that's fine. And I actually put a timer, and I still wasn't tracking myself well enough. Okay. Just filing up the 6 points. You'd have to be sure that the intern does not displace regular employees, that the employer derives no immediate advantage from the internship, and occasionally activities may be impeded. The intern is not entitled to a job at the conclusion of the internship, and the employer and the intern understand that the intern is not entitled to wages. So just to wrap up the unpaid internship, it is a growing area, and I definitely encourage companies to look at the DOL fact sheet and conduct a self-audit. I'm going to skip over the points on the collective and class actions, but finally, in terms of just being prepared for any governmental audit and to do a compliance review, it's important that management be prepared to understand that when you do a review of your wage and hour activity, that you have to accept the findings and appreciate the guidance provided by your in-house or outside counsel. Because if there is a wage and hour issue brought to the management's attention and it's not addressed, and then shortly thereafter or at any point there's a lawsuit that's brought, that's where you can be liable for willful violation, which goes back 3 years. But big things to look at again is your internship, your exempt and non-exempt classification, your independent contractors, appreciating whether employees are working off the clock, and reviewing how the regular rate of pay is being calculated.
Fine. So we're going to move over now to the Affordable Care Act. Cynthia, you all set?
Sure. Hello, everyone, and we'll try to cover things as quickly as possible. The healthcare reform law has created a lot of consternation for employer and other businesses, as well as the people that sell to them. And my focus today is more on the operational aspects of the health benefits. There are many other elements that go into play on other aspects of the law, but I'm not addressing those. And one of the first things about it that's important to look at is that it's kind of the tail wagging the dog a little bit. And so the focus has been so heavily not only on the Affordable Care Act, but even more specifically the particular provisions of what we call the pay-or-play or employer shared responsibility provisions, that not only are many businesses focusing inappropriately on provisions, but overlooking other responsibilities that are much more significant and more applicable. So with that in mind, when you look at the Affordable Care Act, you should look at it in the context of what is the overall responsibility you have in terms of cost, liability, compliance, et cetera, and whether it makes sense and what makes sense, assuming that you take into account those factors, whether your company should offer health benefits or not, and if so, what, and what the consequences of doing that. To do that, it's very important to start with one of the most overlooked, misunderstood areas in health benefit law, and that is that the Employee Retirement Income Security Act that was enacted 25 gajillion years ago in '74 extends to health and welfare plans, and in fact, these days, most of litigation is in the health area. And so, in that sense, the fiduciary responsibility provisions of ERISA apply to people that exercise discretion and control over the plan design, as well as people that are named as the plan fiduciaries. And so most businesses don't put adequate attention on that. There's a lot of assumption that the vendors are taking on fiduciary responsibility, and a lot of misperception about where the responsibility lies. And so the first tip that I have for you is understand the overall responsibilities you have, who is a fiduciary, what responsibilities and liabilities that creates, how they affect the cast of characters, the hats they wear, the responsibility and the resulting liability and cost. For example, there's a big move for many years, but particularly after the Affordable Care Act, for more and more plans to go self-insured so they can have more unique plan designs, afford certain fees, and the like. Taking out insurance can be a great thing to do if you do it responsibly and knowably, but when you take out the insurance and go self-insured, or sometimes what's misnomered as partially self-insured, there's a whole bunch of liabilities, and when you take that out, you also tend to take on much, much greater fiduciary liability and volatility. So start with the basics and make sure you know, and look at the vendor contracts, look at the roles they play, look at the degree of discretion and control, and make your decisions with care. And that also will then inform how willing you are to take risk from these creative advisors who are trying to save you money but are not putting themselves on the line for doing that. The second tip kind of tees off very importantly off of our discussion about wage and hour law, because the common law test of what is an employee is the fundamental starting point for not only wage and hour law, but also the benefits liabilities. And with the requirements that apply to you, not just for the Affordable Care Act, but also all the federal mandates, the size of your plan, the number of common law employees that you have is critically important, as well as when they work, how many hours a week, and the like. And so those of us that practice labor and employment law and benefits law, we can really reinforce to you that it's absolutely critical that you know the hours worked and you document and properly classify your workers and track it. The independent contractor issue is a huge one. Also, the problem of dealing with non-hourly employees who are not traditionally tracked in terms of hours of time. The rules under the Affordable Care Act oftentimes take into account special rules, but they're built on the Fair Labor Standards Act rules and the assumption that you are also tracking hours for non-hourly workers. So you need to know who the workers are and be able to prepare to document that, because it will determine the rules that apply as well as the reporting and disclosure that you will face. Once you know those two things, then you can start by understanding what mandates apply and what ones do not. And that can lead you to the decision about whether to pay or play and what the plan design is going to be and what you have to do to implement it. The next step about that is to absolutely credential and document your credentialing of your vendors, advisors, and other folks, because there's generally a responsibility from the discretionary decision point to prudently select your vendors and implement the plan and then oversee it from time to time. And many people don't do that with the regularity. The Department of Labor is carefully looking at that, not only in the pension area but also in the health and welfare area. And oftentimes when these design things happen, they've disclaimed all their liabilities. So also look at the contracting. I often tell people, go ahead and look, before you look at anything else, send me your vendor contracts. I'll look at the indemnity and the standard performance, and we'll decide at what else we have to look at. You'd be amazed how that will disqualify or substantially focus the discussion and save you some money. The next part about that would be to, once you make those decisions, looking at all those mandates, to update your health plan documents, claims procedures to meet the requirements and to manage your exposures. And this is a place where careful drafting is absolutely critical. The way the rules change in the Affordable Care Act and other laws, the more precisely written your plan is, the more likely you're going to have control over the decisions. And oftentimes the vendors haven't invested very much money or have non-lawyers who are not particularly tracking the law, writing user-friendly documents, and you tend to pay for what you don't say and how poorly you say it. So the mandates are critically important, not only to avoid incorporating violations into the law that can cost you problems and to preserve your status and all of those things, but also to make your expectations about cost there. An important distinction about that will be is if you are a self-insured plan by a single employer that doesn't cover anybody that has another employer that doesn't share at least 80% common ownership with you, you will have much fewer mandates than if you are an insured plan, an association plan, or a plan that covers employees of two or more employers that are not 80% common owned. So that's something to be very careful about. You also then want to clean up your data collection, protection, and reporting. You've got a huge, massive new responsibilities rolling out of data collection, and they're going to be ever-growing. If you're a large employer and you're subject to the potential pay-and-play penalty, that will be part of it. And then there's a whole host of new notifications, reports, and disclosures you have to file, and doing those timely is very important. As part of that, there's early deadlines. There's a 60-day advance notice requirement of any material reduction in benefits, and there are other end-of-the-year requirements that are coming up. So somebody that's coming up for a new calendar year on January 1 probably needs to have their documentation ready. Definitely, if they're cutting any kind of benefits, at least 60 days they have to have their notices out. But in general, you need 90 to 120 days to have everything finalized and get it done, and you may have to extend if you don't. The other thing you really want to do is to work on the carefulness of your communications, and there's summary plan descriptions. There's benefit notices called the SBC that you have to send out, and anytime there's a material change, you have to send it out. There are other notifications that you also have to provide, and getting all those notices out, not only out in time, but well written with the proper fiduciary identified in a clear way that doesn't mess things up for you, is really important. When you look at these documents, be very careful that you retain your right to exit. Know what the termination cost is, your right to amend, what it takes to do it, and what your exit strategy do. And then we all know that Congress is staying on board for this. And so you'll want to be very careful about monitoring the developments. And let me just give you a couple of examples here, and they're not where you might think they would be. The first example would be that we all have been talking about this pay-or-play penalty. It doesn't apply. It keeps getting delayed. At some point, in theory, it'll apply to employers that have 100 or 50 or more full-time employees. But last year, they announced they were going to delay it until 2015 for people with 100 or more, and then 2016 for 50 or more. They've made some more less official regulatory adjustments to delay that further adjust that and bring it down. So realistically, unless you have 180 in 2015, you're probably not going to be covered. And so that's one example. The rules are constantly being tinkered with, and And so even up to the last minute, it's likely you're going to have some delays in terms of those rules, and so you want to monitor that. Another one is some of these creative plan designs. There's something called a scanning plan, which is giving sort of very minimal benefits in the self-insured plan design. We expect when we're at the tax section meeting in 2 weeks from our discussions with senior leadership in the IRS that they're going to narrow, if not take away, that opportunity, and so many employers have moved to that. Those are things you're going to carefully want to monitor. And the reporting, disclosure, and other things are being tinkered with so that we get notices almost every day. So speak up, be diligent, but be careful when you contract with your vendors that you not only are making sure that you incorporate proper drafting and communication in, but you preserve the flexibility to make changes as you go and you stay abreast of those. So I know our time is short, and I want to give time to our moderator to wrap up and to deal with any other issues. If I can provide additional information, I know they provide a mechanism. You can send an email if you need additional details or information about any of those pointers. We have plenty of further details for prior programs we've done for LexisNexis or otherwise. Feel free to reach out with your questions, and we'll try to share some of those. Thank you for listening.
Nice job, Cindy. There's a lot to cover, obviously, with Affordable Care Act. So I appreciate you and appreciate what you did and what all the speakers did. These are complex topics. It's much more difficult to address them in a short time frame than it is a longer one sometimes. So thanks to everyone for that. So on behalf of LexisNexis, this is Tom Hagee at HB Litigation Conferences. I want to thank the panel again and for this excellent webinar. A lot of material covered. The contact information for each of them is up on the screen now. And so if you want to reach out to them, please do. And also, as a reminder, please fill out the survey that's available. Lexis and I and the others on the team take them very seriously and take them as guidance as we create new programs and webinars going forward. So there will also be, after this, is a white paper covering the session. So if you weren't able to keep up with the notes, please look for that. There'll be an announcement about that as well. So you will receive a white paper. And finally, this program also will be up and online, so you can view it at a later time. So with that, we're going to conclude the webinar. Thank you all again. Have a good day.